Welcome, Mr. Risk, Mr. Linden. This is the case of the Department of Talent and Economic Development versus Great Oaks Country Club. It is a mini oral argument on the application. You each have 15 minutes. Mr. Linden, I believe you will go first and you can reserve time, although we ask you to try and keep track of that yourself. And with that, you may proceed.
Thank you, Chief. Mr. Levasseur was supposed to be part and also similarly endorsed.
I am on.
I see Mr. Levasseur's name. Can you turn on your video feed if you intend to argue?
I'm trying to do that now.
Oh, okay. Well, let's stop the clock so we don't use their time while Mr. Levasseur gets situated. There is a little video camera in your lower left-hand corner.
I don't, normally it's, oh, here we go. Sorry.
Oh, you got it. Yeah.
Sorry.
No problem. So I don't know if you all are dividing your 15 minutes, but I will let you all handle it however you want.
Thank you, Your Honor. Good morning, and may it please the court. Thank you for giving us the opportunity to speak here. My name is Jeff Linden. I'm appearing on behalf of the appellant in this case, Great Oaks Country Club, and in the companion cases, AMBS Message Center and NBC Truck Equipment, as well as the other cases that have appeared before this court in the courts of appeal. Mr. Levasseur, we wanted endorsed because he was principally involved in the underlying trials of this case, and if the court had specific factual questions about that record, he would be better able to quickly get to that, but I'll be taking the majority of the lead. I would like to reserve 5 to 7 minutes for rebuttal as well, and I'll do my best to try and take care of that. I'm not going to rehash the pleadings in this case. This case has been briefed extensively and in fact briefed to this court 3 different times. While the names are different, the issues are identical. They're identical in every court that's heard this case, and there are ample of them. It's a statutory interpretation case about a subsection of the Michigan Unemployment Compensation Act that was designed to provide a safe harbor for a particular subclass of employers that use professional employer organizations or PEOs to manage their payroll and take care of their payroll taxes. When the shift came and we're dealing with MCL 421.13M, when it was created in December of 2011, it was very clear. And I want to focus on something that isn't well highlighted in the briefs, but is critical to analysis of why the text of the statute supports the employer's position and why the agency and the Court of Appeals erred. Focusing on the subsection number 2, small a, Romanet 1, capital A is the primary section that we're arguing about, but what is often being ignored is the entire context of the statute, which includes subdivision 2, little a, Romanet 2, and subdivision 2B. And in the first incarnation of the statute, it was very clear that under 13M section 2 creates a mandatory provision that if you meet the gaping provisions of the statute, you're a PEO, that you existed prior to January 1, 2011, you have client employers, and you're in the state of Michigan, you must use section 13M to determine your reporting method and the payment of your rates. And you must follow the protocol that's there for determining rates. Once you meet that gatekeeping provision, you get into 2A sub 1, which says you must have been a client of your PEO on the date that the PEO changed reporting methods. This case allowed under section 2B, and it says a PEO operating in Michigan before January 1, 2011 may elect to use this method, or it can use the old method, but shall report using this method on and after January 1, 2014. In the original incarnation of the statute, if they had not reported payroll for 8 quarters prior to January 1, 2014, and they filed their conversion document on or after January 1, 2014, nobody disputes that you would count the full 8 quarters that ended December 31, 2013 to qualify for their rate. That did change.
Mr. Linden, let me interrupt you. Your time is so short and you wanted to reserve some. So let me just see what questions folks have, and then we can get back to you if they don't. Okay.
Absolutely.
Justice Zahra.
Thank you. Thank you. Can you help me understand when the 12-quarter look-back language would apply? I know you're arguing the 8-quarter standard applies to you because you had 8 quarters not reporting employees or payroll to the agency prior to January 1, 2014. But under what circumstances would the 12-quarter provision apply to you or anyone else?
Under the 12-quarter provision of the current version of the statute, and I don't want to forget that this is the second amendment of the statute created to fix a problem created by the preceding amendment. The 8 quarters was put back in. The 12-quarter section is an alternative. The language of the statute says or. It's an alternative. It means you could still meet. 12 quarters would apply in the circumstance that we outlined in our brief. An example would be an employer that only had not completed 8 quarters by the end of the year, December 31. So it wouldn't meet the 8-quarter provision, but it was out of business. It would have to get a rate, as Mr. Risk has argued in his argument, on January 1, 2014 for 2014. And whatever that rate is, the effective tax would be 0, because if they continued in our example to have no former employees for another 4 or 5 quarters, their tax would be 0, but their rate would be whatever it would be on their employment rate, on their experience rate. However, when they re-entered the system and had active employment, because they were a client employer of a PEO that operated before the operative effective date of 13M, because they were a client employer on the date the PEO switched, Section 2 of 13M requires you to use 13M to determine their rate. At the time they re-enter, they would have met the 12 quarters of not reporting, so they would get the new rate in that circumstance. That's very common in cases of seasonal employment, golf centers, golf courses, places that aren't open between October and March and things like that. It actually happened, not in this case, but in Oakland County, the Novi Golf Course tried to sell itself and shut down for a year and a half. And then the sale fell through and then they reopened, but they didn't have any employees or payroll for a year. And they re-entered the system and did that. So it's a real case. It may be a small example, but this is something that Ms. Tabasco, the agency's representative, testified in the Great Oaks case about, that it's very common for employers to come in and out of reporting of payroll over substantial periods of time. The 12-quarter rule was put in specifically to harmonize 13M with the rest of the statutory scheme, which applies under 19. If you're not a client employer of a PEO in this box, Section 19 applies. Under 13M, if you don't have the or 12-quarter language in 13M, and you're required to use 13M because you've fallen into the safe harbor box by meeting the gatekeeping provisions, if you don't meet the 8-quarter provision, you have nowhere to go. That's where the 12-quarter rule comes in, because it takes the PEO-based employers who are outside of the normal system, and it harmonizes them back after January 1, 2014 going forward. Once the safe harbor provision has completed, once the safe harbor period is done, which is the point of this entire statute, then everybody's harmonized and using the same system, and it'll slowly evolve out so that nobody will effectively use 13M, because as we get further and further away, and by now 7 years later, there aren't going to be any employers that fall in the gatekeeping provision. That's its whole point.
Thank you.
Justice Viviano?
No questions. Thank you, counsel.
Justice Bernstein?
Good morning, counsel. I have no questions.
Justice Clement?
Thank you. I just have one question, and I'm glad that you have Mr. Levasseur here, because he might be more appropriate to answer this. I think I'm just a little confused because it looks like, according to the ALJ report, that Great Oaks had already ended its relationship with its PEO and become liable on its own. So my question is, are we being asked to interpret a statute that doesn't even apply to your client?
Well, I mean, I'll let Mr. Levasseur say that, but no, I mean, the issue of whether or not they have the status of the client of the PEO that falls in the statute is not in dispute, has never been in dispute in this case. It's been conceded by the agency in the ALJ hearing and in every appeal since, but I'll let Mr. Levasseur address it if he feels differently.
Mr. Levasseur, you're muted. You just have to unmute yourself, Mr. Levasseur. There's a little microphone at the bottom left.
Sorry about that. The record was not clear about that. It was not explored. I believe the name was DM Payroll. The name seemed to have changed. Neither party explored that issue because it wasn't really an issue below.
Okay, thank you.
Justice Cavanagh?
Justice Clement asked my question. I'm all set.
Justice Welch?
No questions. Thank you.
Okay, you have 5 minutes and 50 seconds left. You may reserve or you may continue.
I'm going to continue a little because I want to highlight something else in response to Justice Clement's question, which is that your question is an astute one in terms of the record in this case, but this is a procedurally strange situation because Great Oaks, for reasons Great Oaks came to this court consolidated with or conjoined with two other cases, AMBS and NBC, which was consolidated by the Court of Appeals below in that decision. There's a fourth case in the appellate division, Comet, which was previously decided in favor of the employers, as were all these. That case was decided on different grounds. In that case, the lower court and the ALJ decided that the statute was ambiguous, thought that reference to the legislative history was appropriate, looked at that, said that it's completely clear that the legislative history is consistent with what we're saying the statute should be interpreted as, and then went forward. The agency appealed those decisions to the Court of Appeals, and a different panel of the Court of Appeals rejected leave to appeal, saying that the agency's complaint lacked merit. They further appealed, asked this court for leave to appeal, and this court remanded back to the Court of Appeals the Comet case as if on leave granted, literally less than 48 hours before the Court of Appeals issued the opinion in these three consolidated cases, which is bizarre. So Comet, which has the fullest record, a full trial, testimony transcripts, full documentation, and was the first case to be heard, is unfortunately the best case for appellate review if you want to do justice to having the best record and the right result, regardless of the outcome. Unfortunately, because of the accident of timing, it's now the last case in the appellate race, even though it was the first to get here. Great Oaks, AMBS and NBC, because Comet preceded them, were done on summary disposition type procedural grounds as a result. But even if there were an issue with respect to Great Oaks's employment status, that issue doesn't apply to any of the other cases in the appellate system or AMBS or NBC. And if this case is going to control, it would be a disservice to those cases because the same factual issue wouldn't potentially apply there. But I want to get back to the issue. I only have a couple of minutes left. The interesting thing about 2B and what I was saying before the questions was that nobody disputes that under the original enactment, 2B meant that if you converted to client level reporting on or after January 1, you look to the full 8 quarters ending December 2013 to see if they qualify. Even if you filed your conversion on January 2014, you still look to the full 8 quarters that were completed beforehand. When the statute was amended to change the 8 to 12, Section 2B was never changed. Not one word, not one letter, not a capitalization, no punctuation. It remained the same, which means it still means that on January 1, 2014, if you file your conversion report, you look to all the quarters completed prior to that date for qualification. It's just now 12 under that amendment instead of 8. When 13M was amended again only 6 months later to put the 8 quarters back in, they still did not change Section 2B at all. It's completely consistent. The only other change that happened was in subsection 2A Romanet 2, where they changed the period that employers had to be clients of the PEO. They moved it from January of 2011 to January of 2014, evidencing our argument that the intent was to take everybody that was in the pipeline before this conversion date and allow them their safe harbor, not cut off their legs after the fact. They committed to contracts based on the original language. Now that the statute changed after the fact, after everybody was committed to contracts, they're saying, oh, sorry, you no longer apply. That's unjust. It's fundamentally unfair to them. The other thing is that they're arguing without a single change in Section 2B in the text under any version of the amendments. The argument is now that although in the first 2 iterations, you looked at all the quarters completed before January 1, 2014, now you don't, now you lose, now you have to look to September of 2013 as your cutoff date to qualify under the rule for the 8 quarters, although there's no language in the text of any statute or anywhere else in the Unemployment Compensation Act that says so. It's completely made up and it's unsupported. Now, with respect to if there's all of the cases, and there's probably 18 to 20 different jurists that have looked at this case and all consistently with us in 2 competing theories, most of which are the plain language of the statute, one of which is only based on an ambiguity. In this case, the legislative history is clear. The testimony before the Senate says the point was to put the 8-quarter rule back in as it was before. You can't pick from the legislative history in this case to support both sides. Anybody that's ever considered it can only come to one conclusion. And I'll reserve my 35 seconds for rebuttal. Thank you.
Nicely done, counsel. Mr. Risk.
Good morning, Chief Justice McCormack. Zachary A. Risk, Assistant Attorney General on behalf of the Michigan Unemployment Insurance Agency. May it please the court. Great Oaks cannot be assigned a new employer tax rate because the legislature mandated that employers whose PEOs converted to client level reporting on January 1, 2014 were required to report no payroll for 12 calendar quarters, not 8. Great Oaks only reported no payroll for 8 calendar quarters. That fact is not in dispute. They converted to client level reporting on January 1, 2014. That's not the date the form was submitted. That's the effective date of when they begin reporting at the client level. And that fact is not in dispute. And therefore, they had to have had no payroll for 12 calendar quarters, but they did not. So they do not get the new employer rate. And the goal here is to honor the intent of the legislature. And the intent is learned from the plain language. The agency's interpretation applies and harmonizes the plain language and thus honors the intent. Now, in order to fully understand the 8 versus 12 calendar quarter debate, it's important to know what is actually happening here. In 2010 or 11, the federal government mandated that states update their statutes to require employers to report at the client level, not the PEO level. Michigan amended its statute to do so. The first version was in January 2011. The second version was in December 2011. And the current version that we're looking at was effective June 2012. Employers had notice of this change. Even though there were 3 different versions before the ultimate version we're looking at here, employers had notice. And it's crucial to understand that this subsection 13M is only triggered when the client employer's PEO converts to the mandated client level reporting method. We don't even get to this subsection otherwise. And as the Court of Appeals aptly put, the plain language of the statute demonstrates that the date of the change to the method required under section 13M2A is the event that triggers the look-back provisions. And here, the statute is not ambiguous. It's not susceptible to 2 reasonable readings. And as the employer just demonstrated, they cannot provide a clear scenario under which the 12 calendar quarter look-back period would apply to an employer that's converted to client level reporting. If we look at the 3 different versions, the legislative history supports the agency's position. The first version, all employers were treated the same, regardless of when they converted. You only had to have 8 calendar quarters to get a new employer rate. Then the second version required all employers to have 12 calendar quarters. Again, every employer is treated the same. But the final version that the legislature settled on was that employers were treated differently based on when they converted. If they converted prior to the final deadline of January 1, 2014, they only had to report no payroll for 8 calendar quarters. But if you waited until the deadline, as stated in 2B, if you waited to that deadline of January 1, 2014, the 12 calendar quarter look-back period applied. This is why Great Oaks in these companion case employers are treated differently. And notably, it's only the single PEO with its client employers that made the mistake to report on the deadline. There was a misreading, perhaps by their own staff, that resulted in converting on the last possible date under 2B. And therefore, they had to have had 12 calendar quarters. They did not, and so they do not get a new employer rate.
Mr. Risk, let me interrupt you and see what questions folks have, okay? Justice Zahra.
Thank you. It seems to me that section 13M2B, which has been interpreted the same way since its enactment in 2011, supports Great Oaks 8-quarter safe harbor reading. What am I missing here?
Your Honor, 13M2B merely states that employers are required to begin reporting at the client level no later than January 1, 2014. They could do so sooner. And if they did so sooner under 13M2AIA, they would only have an 8 calendar quarter look back period. But under no circumstance could an employer convert any later than 1/1/14. And
Okay, thank you very much.
Justice Viviano,
No questions. Thank you, counsel.
Justice Bernstein,
No questions. Thank you.
Justice Clement,
No questions.
Cavanagh,
No questions.
Justice Welch.
Just one quick one. Thank you, counsel, for your presentation on this. I'm well aware of sort of the unemployment history in the federal law that kind of was a game changer with how these benefits were calculated. What I'm wondering is, obviously 13M, there was a pretty long documented in the briefs history as far as what the intent was as far as PEOs. It does seem that the legislature really did try to create this little temporary carve out for PEOs. And I'm just wondering, are you asking us to ignore that?
Your Honor, this statute, as the Court of Appeals found, is not ambiguous. We do not look at extrinsic evidence unless there's a finding of ambiguity. And under the state standard, there is no ambiguity here. And even so, the plain language mandates that if you converted prior to 1/1/14, you could get that shorter look back period, an incentive, if you will. But if you wait to the deadline, the 12 calendar quarter look back period applies. And that is consistent with Section 19, which is the standard default look back period for all employers. Does that answer your question?
Yes, thank you. I appreciate that.
You have some time left. You may continue.
Thank you, Your Honor. As I just stated, the agency's reading is harmonious with the entire act. Section 19, as the Court of Appeals noted, requires that employers who report no payroll for 12 calendar quarters, that's the standard look back period. If they report no payroll for those 12 calendar quarters, then you get the new employer rate. And the reference in Section 13M is to be consistent with that, that once January 1, 2014 came to be, that all employers now had to report at the client level, they had to convert, and therefore you would only get the shorter look back or the new employer rate if you had no payroll for 12 calendar quarters. Great Oaks did not have that here. Other employees, other PEOs converted well before 1/1/14. As I said, for whatever reason, Great Oaks, its PEO, and the companion employers in these cases did not convert until January 1, 2014. And again, it's not when the document is filed. It's a single one-page document that elects an effective date of converting to client level reporting. It's not when that piece of paper is submitted to the agency. It's the effective date of when the employer is going to begin reporting at the client level. And Great Oaks, in all these cases, all the client employers elected to convert 1/1/14. Finally, if it's not already clear, this is a very limited dispute. It can't be repeated again. All employers, as the Section 2B requires, they had to convert effective January 1, 2014. So there has been no subsequent conversions. Every employer since January 1, 2014 has been reporting at the client level. And for these reasons, the Court of Appeals got it absolutely right. There's no ambiguity. Great Oaks just didn't convert soon enough. And as a result, the 12 calendar quarter look back period applies. And for that reason, the agency would ask that the Court of Appeals decision be affirmed. Thank you.
Thank you, Mr. Risk. Mr. Linden, you have 35 seconds. You are muted.
Sorry, Your Honor. I'll do my best. The federal law issue, if you read the statute, it deals with reimbursement. It doesn't deal with the issue that we're talking about here today, and it's not part of the record below in this case. 2, 6 ALJs, different ones, 3 MCAC panels, 4 different circuit court judges, and at least 3 judges of the Court of Appeals felt differently than the 3 judges that in the Court of Appeals that handled differently. They like to say it's not a popularity contest. I understand that. One set of those judges found that the statute was ambiguous. It's ultimately up to this court to decide. But all of those judges, except for the comment series, found on the face of the plain language of the statute that it was clear and unambiguous and our side was correct. Only these 3 judges are an outlier saying no. If that's not ambiguity in this type of case, I don't know what is. Thank you, Your Honor.
Thank you very much. The case will be submitted.